You've prepared all of your paperwork. Your case seems to be ready. Your attorney's ready. You're ready. You want to get divorced, and you want it to happen in a very short amount of time, or what we call a reasonable amount of time. But then you hit a stumbling block. That stumbling block is service of process. Service of process is mandatory. It is Florida law. The other party must be served by service of process unless they accept email service, which can happen in uncontested cases. But if your case is contested, you anticipate litigation, or if you have a hard time finding the other person, know that you must get them served. They must be served with process according to Florida law and according to those specific guidelines. There's no way around it. You cannot send your documents by mail or certified mail. You cannot hand deliver your documents if the other person is contesting the divorce. Instead, you have to get them served, which can be troubling and difficult. You may have to do a skip trace to find out where they are. You may need a background search to find out where they work, where the most recent address is. It's not always easy to find a person, especially if they want to avoid you, or if they themselves or herself do not want to get divorced. They may seek to avoid service. One way to effect service properly is to have your attorney work with one of their process servers. We work with some really terrific process servers. Although that's no guarantee, this helps us make several attempts. So we can do rush service, a priority service. There are any number of manners and means in which we can serve the other party in a timely fashion when it's necessary and when it should be done, to try to capture them at just the right moment so that way your case can officially begin. Until they've been served, that 20-day clock for the other party to answer does not start. And once your summons is issued in your case, you only have 120 days to then get the other party served before you need a new summons, or perhaps your case might be ripe for dismissal. It's very important. If you try to approach the family law court with inadequate service or process, or inadequate substitute service that's not truly substitute service, the case might be dismissed, you might never get a divorce, and this might be problematic, which often happens in cases where the other party lives abroad, in the Philippines, in Brazil, in Mexico, in Saudi Arabia, in Germany, in England, in China, and any number of places where service might be affected according to law. It might be time-consuming to get them served, and it might be difficult to find the location of that other person. Florida requires service of process to ensure the other party has notice, proper notice for purposes of due process. They take this very seriously, and so should you. Thank you.